to prove any specialty or special characteristic of Chong Choroi security prison. The Defense Counsel indicated under paragraph 43 of their appeal brief that Chong Choroi was another important security center. It indicated that if Dutch were most responsible for the crimes committed under the framework of S21, other security center would have been also charged or prosecuted. However, if it is according to the submission by the co-prosecutors that they had no bound to prosecute all the head of the security center all across the nation, I'm referring to the 195 security prison, then Dutch should be also free. The prosecutors would like to draw your attention to the submission by the Defense Counsel with reference to the prison of the Khmer Rouge prepared by Peng Pung Rasi, who indicated the location of security centers all across democratic Cambodia, and that the defense picked Chong Choroi as the main prison to challenge with the existence of S21. However, these co-prosecutors would like to submit that there is no clear indication regarding the special characteristic of Chong Choroi security prison to prove that it has a different characteristic as opposed to that of S21. According to the document entitled The Chain of Terror, written by Ear Meng Tri, which really lists the structure of security center of democratic Cambodia. There were five kinds of security centers, including the lowest one, the commune militia office, and then the security centers at district level and sectoral level, and also the zone level. And the highest security center was at S21, which is at the center party. Regarding Chong Choroi, as submitted by the Defense Counsel, it was only the district level security center located in Ro Liep Ia, Kampong Chnang, Sector 31. West Zone. This document is relating to the security center as submitted in the request for additional evidence by the Defense Counsel. The prosecutors would like to submit that this evidence is not new at all. It has already been put in the case file, and the prosecutors have also been familiar with this document already, and that Chong Choroi Security Center could not be used as reference to challenge the ECC jurisdiction over the accused.
Regarding the documents in relation to the biography of 31 people, for this document, as Dutch lawyers requested in the new evidence and accepted by the Supreme Court chamber, the co-prosecutors maintain the same position that these documents already exist in the case file. The 3-page document, although it is not in the case file, and that we are not surprised by this 3-page document. The reason is that we have already known the content that Kang Kech Il alias Dutch is chief of S21 prison, who worked on the confessions implicated Chakray Chuk Li Pan in order to conduct the purge, and for the senior people, Pol Pot, Nuon Chi and Son Sen, and those subordinates include Ho, Mom Nai, alias Chan, Pon, who executed Goitun, Vonvethunem, with his annotation that smashed them to pieces, as in the record of the interview before the co-investigating judges and during the adversary hearing before the trial chamber. We would like to make the observation on the statement raised by Dutch Defense Counsel at the trial chamber. During the hearing on the 1st of April 2009, when asked by the co-prosecutors whether the defense team objects to the personal jurisdiction, the response was no. If I were to raise it, I would have raised it during the initial hearing. So this is just a snapshot for your honors to examine regarding the issue of personal jurisdiction. And right now, before the Supreme Court chamber, the defense would like to reinstate the issue of personal jurisdiction, and that Dutch does not fall under the jurisdiction and he shall be released. This submission is contradictory to the content of Article 89 and Article 87 of the internal rules, which in 89 it states preliminary objection in regards to personal jurisdiction shall be raised during the initial hearing, otherwise they cannot be accepted. The additional evidence shall have direct link to the arguments, concrete arguments raised by the trial chamber. Therefore, for the new evidence submitted by the defense team, only the document that is already in the case file and the additional evidence that the defense team submitted, we, the co-prosecutors, would like the Supreme Court chamber to dismiss it, to reject it, and that the Supreme Court chamber shall decide on the personal jurisdiction that Dutch falls within the jurisdiction of the ECCC as stipulated in Article 1 of the ECCC law. I would like to take this opportunity also to make our observation in regard to the transcript of the 1st of April 2009 on page 13 and 14, when the defense team clearly replied, and his reply is in the transcript, that he is not going to raise the issue of preliminary objection on the personal jurisdiction, and that his objection is only to deal with the 1956 Penal Code. The defense team always reiterated that Dutch falls outside the jurisdiction of the ECCC, and that S21 also has a similar hierarchy and status of the other 195 prisons, in particular the Jongchoi prison, and that Dutch shall be acquitted. This interpretation by the defense team cannot be accepted, and we would like, therefore, the Supreme Court chamber to dismiss the appeal by the defense team. I'm obliged, Your Honor. The President, the International Co-Prosecutor, would you like to make a statement or response?
Not at this time, no. Thank you, Mr. President.
The President, I would like now to seek the judges of the bench if you have questions to put regarding this matter.
the co-prosecutors, we need some assistance from you on this, the position taken up by the defense that the senior leaders of the democratic Cambodia and those who are most responsible should be read conjunctively and not disjunctively. The whole basis of the defense argument was on the basis that the appellant is not one of those most responsible. So either Mr. Kelly or Madam Chairling would address court on this, please.
Chilean, thank you, John, for the question. This is an important question in regards to personal jurisdiction. The co-prosecutors would like to respond as follows. We have the view that in Article 1 of the Law on the Establishment of the ECCC, it states that it is to prosecute those for crimes committed during the Democratic Cambodia regime. And there are two categories of people to be prosecuted, that is, the senior leaders and those who were most responsible. We are of the view that in this instance, in particular in this case, we only focused on one of the two categories, that is the most responsible, and we will rely on our discretion to charge people in relation to this group. That is also in consistence with Article 40, and we exercise our discretion is based on the facts and the existing law. We as co-prosecutors can assess the documents we collect during the preliminary investigation so that we can submit it to the convicting judges for further action. And during the preliminary investigation, we consider that Dutch was within the category of those most responsible based on the existing law and facts. And regarding our authority or the discretion to make such a decision, as well as the view formed by the co-investigating judges and the trial chamber in agreement to our decision for the charge against the accused. And with your permission, I would need about 8 minutes to make this short statement, Your Honor.
May I ask the co-prosecutors again, now did the draftsman of the ECCC law and the agreement ever contemplate prosecution of democratic Cambodian leaders who had not been guilty of any culpability? See, if you are saying that the two situations of senior leaders of Cambodia and those most responsible are disjunctive, then what is the culpability that could have been attached to the senior leaders of democratic Cambodia who did nothing between 1975 and 1979?
ខ្ញុំមិញដោយសារខ្ញុំមានការឆ្លើយវាមានពាក់ព័ន្ធទៅនឹងការបកស្រាយទៅលើអ្វីដែលសហព័ន្ធ
My response was in the intention to the interpretation
បានសួរនៅថ្ងៃទី23ខែមីនាឆ្នាំ
of the question put by Your Honor on the 23rd February.
ថាมันមានចំណងចាំបាច់ត្រូវតែទាំងពីរនោះទេ
Of course, for us, there is no need for us to consider him for the two groups, for the senior leaders or for those most responsible. And of course, these two groups are disjunctive. And I'd like to respond to Your Honor, in particular on the group for those who were most responsible. And also, I would present to you our discretionary power based on the law and the facts to charge Dutch for the crimes committed within the framework of S21. Within the jurisdiction of the ECCC, the co-prosecutor clearly stated, based on the existing law and facts, that Dutch clearly fall within the group of those who were most responsible. The co-prosecutors exercise their discretionary power that Dutch falls within the group of the most responsible, relying on several facts that I would summarize as follows. If you would grant us the time, then I would be able to make a brief presentation. The President, yes, you may proceed. Co-prosecutor. We have reasons to believe that Dutch did commit the crimes within the framework of S21 as chief of the security office in identifying the persons in our preliminary objection before we send our interactive submission to the co-investigating judges. First, we need to exercise our discretionary power to charge, and then we need to assess the facts based on the existing law. We maintain the spirit of Article 1 of the law on the establishment of the ECCC and the spirit of the preamble of the agreement between the United Nations expressing the concerns of the royal government of Cambodia as well as the willing of the Cambodian people to find peace, national reconciliation and peace. In our interactive submission, we considered Dutch as chief of S21 prison, which is at the central level, and it is at the highest level of the security center offices during the Democratic Cambodia regime. The exercise of the discretionary power, as I stated above, we consider the circumstances in which the crimes were committed, and that the charges does not interfere with the peace or stability of the society. The co-prosecutors also consider the views of other international prosecutors, for example, the Special Court in Sierra Leone, that it recognized the necessity to consider the extension of the charges in regard to the stability and political stability in society, and the charges shall not interfere with the national reconciliation and peace within the country. After deciding to open the investigation by the virtue of the introductory submission, with respect to the spirit of the preamble of the agreement between the UN and the government, the co-prosecutors also took into consideration the meaning of Article 1 of the ECCC law which does not require the co-prosecutors to charge all suspects, in particular in the case that was submitted by the defense team for all the security centers throughout the Cambodia, that is 195 to other security centers. The statement is incorrect because the security centers expressed by the defense, including Chong Troi in Roliep District, Kampong Chnang Province, in the West Zone under the supervision of the Central Zone, based on the decision dated 30 March 1976. In contradictory, S21 is located within the center under the supervision of the Central Committee, and that is based on that decision as I mentioned above. So, it falls under the jurisdiction of the ECCC, and the decision to decide that Dutch falls under the jurisdiction of the ECCC is based on a number of reasons. We not only rely on the international jurisprudence at Sierra Leone, we also consider the specificity at S21, for example, the role and authority, the jure and de facto authority of the accused. For example, his supervision over various sections of S21, as well as the numerous surviving documents. And these documents have already been put in the case file. On the contrary, the defense team did not find any remaining document from the Chong Troi prison. And regarding the exercise of the discretionary power based on the spirit of the ECC law and the preamble of the UN and the government agreement, and based on the other jurisprudence of the Special Court of Sierra Leone, that we, the co-prosecutors, have the power to charge or not to charge any person based on Article 40 of the Code of Criminal Procedure of Cambodia, which clearly states the power to charge or not to charge in the introductory submission. Regarding the fact that Dutch falling within the jurisdiction of the ECC also agreed by the co-investigating judges and found to be appropriate by the trial chamber in its judgment. After our initial preliminary investigation, we charged 5 persons in our introductory submission for the facts stated in that submission. And after 1 year investigation, that is on the 8th of August 2008, the co-investigating judges issue a closing order or indictment, charging that although Dutch was not a senior leader of the Democracy, Dutch is considered in the category of those who were most responsible for the crimes committed as Dutch. That is, this is the reasoning of the co-investigating judges, that Dutch has the power as the deputy and then as chief of S21, which is under the direct supervision of the Central Committee. And the trial chamber later agreed to the evaluation of the assessment by the co-investigating judges that Dutch falls under the jurisdiction of the ECCC as a person who is most responsible for the crimes committed during 75 to 79. The decision of the convicting judges and the trial chamber that Dutch is the most responsible person and under the jurisdiction of the ECC is a decision consistent with the discretionary power of the co-prosecutors. These are the reasons based on facts and law applicable and existing law that Dutch fall under the jurisdiction of the ECC. I thank you, Your Honor. The President, Judge Noguchi, you may proceed.
I have one question to the co-prosecutors. Both parties have been discussing Article 2 of the ECC law, the expression of senior leaders and those most responsible. Could you provide your understanding as to the nature of these wars? Either these are jurisdictional requirement subject eventually to a judicial review, or these are merely a guidance for co-prosecutors in exercising its prosecutorial discretion. Thank you.
ក្នុងការប្រាជ្ញានុសិទ្ធិរបស់សហប្រជាញ្ញាក្នុងការចោទប្រកាន់តែប៉ុណ្ណោះសូមអរគុណ
សូមអរគុណលោកចក្រមឲ្យខ្ញុំនឹងឆ្លើយនៅ
Thank you, Your Honor, for your question. I think the issue is not related to the jurisdiction, rather it is related to the competence and the prosecutorial discretion. The President, Judge Millard, you may proceed.
Madam Chialing answered my question. Thank you.
Mr. President, may I add something very briefly? Question that was put by Judge Singer earlier about whether or not this phrase, senior leaders and most responsible, is disjunctive or conjunctive. And I can answer it very briefly, and I certainly support all of the comments that have been made by my learned friend, the National Prosecutor. But if I could refer you, Judge, to paragraphs 27 and 28 of our response to the defence appeal. And that gives insight, I think, into the minds of both the United Nations and also the Cambodian government. Certainly, if one looks at the agreement between the government and the United Nations on one side, and then the domestic legislation passed by the Royal Cambodian government on the other side, you will find that, in fact, the UN group of experts prior to the agreement in 1999 stated very clearly that there were two types of individuals who should be prosecuted, namely senior leaders with responsibility over the abuses, as well as those at lower levels who are directly implicated in the most serious atrocities. Subsequently, in debates in the Royal Cambodian Government Parliament, in the Cambodian Parliament, Deputy Prime Minister Sokhan explained that Article 2 of the proposed law that followed the agreement between the United Nations and the Royal Government allowed the prosecution of two types of targets. One, senior leaders as opposed to persons who held ordinary positions, and two, those who were not the senior leaders but who committed crimes as serious as the senior ones. So I hope that helps you, Your Honour, in your determination of this issue. Thank you.
ថាលោកលោកស្រីចៅក្រមនឹងពិចារណាទៅលើបញ្ហានេះដោយអ្វីដែលខ្ញុំបានបញ្ជាក់នឹងលើកឡើងអំបញ្ញមិញសូមអរគុណ
The President, it is now appropriate to have a break. We shall adjourn for half an hour and we shall return at 3:30. Security officer, you can now take the accused back to the waiting room. Graphic, all rise.